judge bench is all set to pronounce on whether or not right to privacy is a fundamental right. There's a very important issue which is mainly stemming out of the case that was going on regarding the challenge to the Aadhaar scheme that was started by the central government. Let's remember, it was the challenge to Aadhaar was on the basis that Aadhaar in fact violated the fundamental rights of the citizens, and the petitioner stated that the fundamental rights were violated because there was a violation to right to privacy. The central government, on the other hand, clearly stated that right to privacy was not a fundamental right at all. It was in fact a common law right that was granted to the citizens. It was then that the bench that was hearing the Aadhaar judgment actually transferred the case to a 9-judge bench to decide whether or not fundamental rights included the right to privacy for the citizens. Of course, the hearing today, the verdict today, will have large-scale implications not only on the Aadhaar scheme, for which the central government, through Attorney General K.K. Venugopal, has made some very strong points, but also towards the other cases. In fact, we had heard Justice D.Y. Chandrachud, who is one of the judges who was hearing the case in the 9-judge bench, specifically stated that if right to privacy is held to be a fundamental right, then that would raise severe problems to the Naz Foundation judgment, which was in fact the judgment that had criminalized homosexuality, Section 377 of the Indian Penal Code. So extremely important judgment today, pronounced by a bench of 9 judges. So of course we'll have to wait for the majority to hear exactly what the final verdict of the Supreme Court is going to be. But anytime soon we can expect the judgment to come.
Nalini, if you can tell us, tell our viewers what has been the government's stand on right to privacy before this, in the hearing that happened over the months.
Yes, Anika. In fact, from the very beginning, the government has been making very strong points against right to privacy, stating that it is not a fundamental right, it is a common law right. The main reason for that is because the case stems out of the challenge to Aadhaar. If the right to privacy is held to be a fundamental right, then that would have very large-scale implications on the Aadhaar scheme itself. The amount of money that the government has already spent on Aadhaar would all go down the drain, considering the fact that when it's an issue of the fundamental rights of citizens, the state or the government cannot do anything in violation of that. So clearly there is a large problem of data leakage when it comes to the Aadhaar issue, which is being debated from a long time. Considering that aspect, the government has taken a very strong stand against right to privacy, even though since 1975, we've had multiple judgments that in fact recognize the right to privacy as a right that is being granted to the citizens of the country. The main issue that the government is opposing is the fact that it's not a fundamental right. It might be a right granted to the citizens, but it is a common law right and not a fundamental right. The main aspect of fundamental rights is that these rights are granted to the citizens against the government. So there is nothing that the government can do that can actually violate your fundamental rights. That is why we've heard some very strong arguments from Advocate General K.K. Venugopal, who has been trying to defend Aadhaar and in view of that go against the right to privacy, clearly stating that right to privacy should not be upheld as a fundamental right for Indian citizens.
This government essentially was quoting those 2 verdicts, and that's exactly what their premise was. Right. But many say that this 9-judge bench at the moment is more powerful constitutionally to, even change that or upturn that verdict. Not sure if that would happen. And before I come to you, Mr. Rajshekharan, this is also the former Attorney General Mukul Rohatgi reacting on what to expect from the Apex Court this morning.
Bench judgment which says that privacy has no part in the Indian Constitution. So it is not what we were saying or what the other side was saying. This is what the court had said 50 years ago. But from the hearings and the debate which went on, it appears to me that the government has said that privacy is a part of fundamental rights. But what are the contours of that privacy will have to be examined. Now, for example, if you have a mobile phone and you use a phone, you know where the person is. If you have a credit card and you use it anywhere in the world, then the company will know where you are. If these are also considered to be aspects of privacy, then it is impossible to live in a regulated society. And according to me, use of Aadhaar for the benefits of Aadhaar, for the benefits to the poor, for PDS and for security issues, etc., I don't think there is any question of violation of any privacy.
राइट है, इसका मायना ये हुआ कि अगर राइट टू प्राइवेसी इंटरफेयर होती है तो वो धारा प्रोविजन को स्ट्राइक डाउन किया जा सकता है।
इसका आधार के ऊपर बहुत बड़ा इम्पैक्ट पड़ेगा।
हाँ, आधार के ऊपर इम्पैक्ट पड़ेगा क्योंकि जो आपकी बायोमेट्रिक डाटा डिस्क्लोज हो जाता है, हालांकि पीछे ऐसे भी पता लगा कि गवर्नमेंट की वेबसाइट पे कुछ आपका प्राइवेट जो डाटा है वो वेबसाइट पे आ गया, तो इसका बेशक एक्सीडेंटली आया हो, लेकिन इसका मतलब ये हुआ कि जो इंडिविजुअल का जो राइट टू प्राइवेसी है, जो फंडामेंटल राइट का पार्ट है, वो वायलेट हो रहा था। लेकिन अब ये वायलेट नहीं हो सकेगा, क्योंकि सबसे पहले डिसाइड करना ये था, क्योंकि जो MP शर्मा की जजमेंट थी 8 जजेस की, वो ये कहती थी कि ये फंडामेंटल राइट नहीं है। इसलिए प्रॉब्लम ये आ रही थी कि सिटीजन के लिए कि जब तक ये फंडामेंटल राइट की कैटेगरी में नहीं आएगा तब तक इसकी वायलेशन तो होती रहेगी, क्योंकि संविधान में सिर्फ ये लिखा है कि फंडामेंटल राइट अगर वायलेट होता है।
क्या ये कहना सही होगा दैट नाउ द सिटीजंस हैव द राइट टू नॉट गिव देयर बायोमेट्रिक डिटेल्स एज पर आधार बिकॉज इट्स अ फंडामेंटल राइट?
हाँ, बाय इंसिस्टिंग दैट इट इज ए फंडामेंटल राइट, इसीलिए जो आधार कार्ड के थ्रू इन्फॉर्मेशन रिलीज होनी है वो राइट टू प्राइवेसी के अंतर्गत आने में इंडिविजुअल सिटीजन इसको डिनाई कर सकता है, मतलब इसको लिखने से मना कर सकता है, क्योंकि ये फंडामेंटल राइट है, इसका हनन हो रहा है। हालांकि हो सकता है इंडिविजुअल राइट्स के लिए सेपरेटली बेंचेस बन के उसको डिसाइड करें, लेकिन जहां तक ताल्लुक है मेन पिटीशन का, जो इसने ये चैलेंज किया था कि ये फंडामेंटल राइट है कि नहीं है, और 9 जजेस की बेंच इसलिए बनी क्योंकि 8 जजेस का फैसला ऑलरेडी उलट था कि ये फंडामेंटल राइट नहीं है। इसलिए आज बहुत बड़ी जीत है भारतीय सिटीजन के लिए कि फंडामेंटल राइट जब बन गया है तो उसके प्राइवेट राइट्स का हनन नहीं हो सकता।
एक और सवाल, सरकार ने कहा है कि नेशनल सिक्योरिटी की इम्प्लीकेशंस बहुत मैसिवली इम्पैक्ट होती है अगर आप एक फंडामेंटल राइट टू प्राइवेसी दे देते हैं। व्हाट इज योर रिएक्शन टू दैट?
नहीं, देखिए, अब जब 9 जजेस बेंच ने ये डिसाइड किया है कि ये फंडामेंटल राइट हो चुका है, इसीलिए जो गवर्नमेंट का, देखिए, कोई भी नेशनल सिक्योरिटी एक्ट है या कोई भी दूसरा एक्ट है, उसके प्रावधान अगर आपकी राइट टू प्राइवेसी या फंडामेंटल राइट को वायलेट करते हैं वो तो बात और है, लेकिन मान लो कोई अक्यूज्ड है या कोई ऐसा व्यक्ति है जिसके खिलाफ ऑलरेडी कोई कार्रवाई चल रही है, उसके प्राइवेट राइट्स अगर हनन होते हैं तो वो बात सेपरेट है, वो विद इन द पैरामीटर्स ऑफ दैट पर्टिकुलर एक्ट देखा जाएगा कि हनन हो रहा है कि नहीं हो रहा।
थैंक यू सो मच।
ओके, थैंक यू। R.K. Kapoor judgment on the right to privacy, whether it is a fundamental right or not. The Honorable Supreme Court, by constitution of 9 judges bench, because earlier there was a 8 judges bench decision in 1954 holding that right to privacy is not a fundamental right, but today by the 9 judges bench has held that the right to privacy is a fundamental right. Therefore, now onwards, if any information which interfere with the right to privacy, that can be declined by the individual by saying that it is a violation of his fundamental right. The judgment of 8 judges bench of 1954, MP Sharma case, that has been overruled, as well as the 1962 judgment of Khadak Singh, that has also been overruled today by the 9 judges bench. Therefore, holding that the right to privacy is a fundamental right.
So could you tell us about the implications of this on Aadhaar?
Yes, implications of this on Aadhaar would be, there are two things. One is that if individual cases are to be decided by separate benches, they will have to decide on the basis that the right to privacy is a fundamental right. Now, when the Honorable Supreme Court already decided it is a fundamental right, therefore all those petitions will be decided by respective benches by taking into consideration that it is a fundamental right. Therefore, any interference of the private rights would be struck down by any given bench, since the 9 judges bench had given a clear pronouncement.